Now, under Florida law, we have assets that a creditor can't take even if they have a judgment against you. Your homestead, your annuity contracts, your permanent life insurance contracts, those are creditor proof under Florida law. Your IRA, your pension accounts, your 401k, all creditor proof under Florida law and the laws of many other states. But if you put those assets under a revocable trust, they may not be creditor proof. The Florida law says a person owning life insurance, a person owning an annuity. It doesn't say a person's revocable trust, and we don't have test cases on that. Well, then the question becomes, I live in Florida, my spouse who's the beneficiary is in Florida, and the creditor is in Florida, and the creditor sues me, and I say, you can't touch that Nevada trust. Look at the law of Nevada. And the creditor says, but look at the law of Florida. I'll go try to get a Florida judge to say that it's against the public policy of Florida for you to have set that up, and that in substance, this is a Florida trust, because even most of the assets are controlled from Florida. Florida, Pennsylvania, Wyoming, Delaware, and are the states that recognize pure protection for any kind of tenancy by the entirety's asset. So my wife and I have a joint tenancy by the entirety's bank account. If one of us dies, the survivor owns it, but while we are both living, if you get a big judgment against me or her, but not both of us, you cannot reach the TBE asset. What some clients do is they buy a lot of term life insurance and put the term life insurance in the ILET. And then they buy a permanent policy with a very high ratio of cash value to death benefit, and they own that outright to get the creditor protection and to have the tax advantage of the ability to let that cash value grow. And then, if needed, you can borrow it out income tax free. You could take money out up to your basis income tax free. And at least in Florida and many other states, creditors cannot take the money that you pull out. If you have a family limited partnership or an LLC, don't put everything in it. Don't put anything that's going to cause liability directly under the partnership. If you're going to make mortgage loans and you may be violating the Dodd-Frank law, put it in a separate LLC so when you get sued by the borrowers, you don't lose everything.